Good day, everybody. With me is Mr. Brian Burke in his home. This is Sam Shihab and Associates for our weekly presentation. And Happy New Year, everybody. It's 2022, and we are about to talk about preparing for 2022. Last week we talked about what is going to happen in 2022. We're going to talk today about how to prepare for them. Brian, how are you today?
I am doing absolutely fantastic, sir.
But before we even dive into this, there's something really happened important in the last few hours that
Yeah.
hit the news today. That's really a big deal. Brian, walk us through it.
Well, it seems the Build Back Better Act may be back on track, and
You don't say.
I did say it. It was very hard. I had to practice saying it a couple times before I could. So last year in December, Joe Manchin famously torpedoed the Build Back Better Act with his thumbs down on Fox News in an interview, and he said I couldn't vote for the bill. And the reports today are he's back at the negotiating table. So what are the issues? It's the same issues holding up the bill that they were before. It's the child tax credit, and it's basically the massive scope of it. Joe Manchin's concerned about inflation. But Sam, on an immigration front, talk about that. What's still in it?
Well, first of all, we know that the illegal immigration is gone. The parliamentarians shot it for the third time. We also know that we have no negative information on the legal piece. And the legal immigration piece, one is the recapture, going back and recapturing all the racist green cards since 1992, which it depends on who's calculating, and the method of calculation ranges between 500,000 to 1 million green cards, of which 250 to 400,000 legal employment-based green cards. So that has never been discussion in anything negative. As a matter of fact, nobody's opposed to it that we have heard. And obviously the super fee for the super premium processing green card, which I have doubt that this will ever survive, but it's not dead. That doesn't look like it's dead to
We were
what I have
talking
been reading.
before we went live. I mean, the visa recapture, there's precedent for doing that. It's been done in the past. However, that super fee just kind of breaks my immigration attorney brain because that's just such a huge change in the system. But Sam, I got to point out, when Joe Manchin gave his famous thumbs down, I was a bit gloom and doom. I said, Sam, he seemed to really committed to that no. And you said, Brian, we'll see Build Back Better Act coming back in the next year. And here we are, and I'm going to bow down and say you are right. It's back.
Yes. It appears to be back. I mean, obviously, this is the first piece of information that just got released. That's
the reports.
Joe Manchin is coming out of, I don't want to play anymore. I don't like this. I'm not having fun. And now he's willing to play, but he wants to play within his rules. And his rules, his way or the highway. You are going to, guys, listen to me, do it my way, or I'm not doing it. He obviously got a lot of flack from a lot of people from his state and all over the country. He became the number one hated person in America through many other groups who are pro-immigration and some union members. So he's now coming back and say, all right, I'm willing to talk, but on my terms, which is fine with me.
Well, Sam, $1,000 question. I know predictions are very hard, but what do you think? Do you think you said a couple weeks? Do you think it goes through? Months back, I was at 90% certainty, and I still believe in it. That's the president's signature, everything, and he wants it done.
You said it. I mean, if this thing does not go through, it's truly a problem for Biden. I mean, Biden hasn't said he's not going to run again, which everybody thinks he's crazy for even thinking to run again as president. But at least he wants to leave with a legacy. If it's a one-term president, which I think it's going to be a one-term president, and this is his signature piece, and he wants to pass or salvage of it as much as possible.
Yeah, I mean that's politics. It's not what we usually talk about, but man, for the immigration stuff, it'd just be so huge, and thereby we just can't help bringing it up. So
yes.
do we
Okay,
segue,
sounds
Sam?
great. So we're going to be talking about, we've talked about a lot of things about what to expect in 2022. We're going to talk about how to prepare for them. Obviously, we see questions coming through regarding the waiver. We're going to talk about the waiver, the process, and clarify it. And don't go away. Obviously, TV production is not my gig, but I'm doing the best I can without Brian's help here on my own. And I'm very proud of what I've accomplished so far. So I was able to play the music without a problem.
No, I'm very proud, Sam. It was very terrifying to be down in the lower right hand corner of the screen all by myself, though. I can tell you that.
So let's talk about the main issues we're going to be talking about today. We talked about that there's potentially, because we're really now pausing a little bit about increased visa availability. We're going to talk about some H-1B changes. We talked about that and what to expect and a few other things. But on the increased visa availability, Brian, do you think there's going to be a rollover?
So this is what we prepare for our presentations pretty thoroughly. We had a meeting this afternoon and we talked about this, and we basically spent some time looking at the numbers. The big number. Well, let's remind everybody: visa rollover happens because the employment categories, of course, happens when they go unused in the family category, and due to COVID, there was massive rollover because basically the consulates weren't open, they weren't issuing immigrant visas, and that's that, right? So we were looking at the number as of sometime back in November. The Department of State predicted as of January 1st there would be about 450,000, a backlog of 450,000 cases at the consulates, and that's huge. And we look back at the last couple of months, they seem to be scheduling about 25,000 interviews a month, and it seems like the Department of State is actually functioning pretty well on their issuance of visas to the consulates. That's the conclusion we came to. But the question is there going to be rollover? And there's a lot of factors at play there. Is what we were stuck with.
So 26,000 interviews per month. That tells me. I mean, obviously we talked about they need to issue 18,800 approvals in the non-immediate relative category per month throughout the year to not have a rollover
of 220,000.
Yeah, but it seems to me some rollover will happen, but it may not be at the magnitude that we've had. So we're adjusting. We're pulling a Charlie Oppenheim here. We're waffling from month to month, but obviously it's based on the data that we're reading that's released from the State Department. And again, it really depends on what's going to happen in the next 10 months.
Yeah. So we have that to look forward to, and we still have the prospect of the Build Back Better Act happening. So what we're talking about today, Sam, is what do we do about it? What do you do? How do you prepare?
Yes. Well, first of all, let's refresh people. Recapture, right? Recapture, if it goes through, there'll be tons of green cards also, and how to prepare for them. So we have the first advice to people regarding employment.
So the general idea is to stabilize your employment. So I don't know about you, Sam, but I've had a lot of consultations with people lately where they're thinking about changing their employer and they have a pending green card. And the challenge they're facing right now is, they're wanting to change employers, but they know their priority is coming up. And the question is, can they change their employer right now? And for some, it might not be a good idea. As your priority date gets closer, the challenge you have is if you need to change employers, you need a new perm, you need a new I-140. How long does that take right now? You're looking at about 5 months to get a prevailing wage, another 2 months of recruitment, another 6 months of processing, more than a year to get an I-140 in place. And that's really one of the challenges you're dealing with right now. If you're planning to change jobs, well, you might have to rethink it, because if your priority date's coming up, you don't want to be the guy or gal who missed out upon having, your priority date's current and you can't file a case. It's a nightmare.
Have you found a correlation between late employment changes and late Supplement J filing and early Supplement J filing and adjustment interviews?
So
in
yeah,
your opinion? Now we
that's one of
discussed
the
about that earlier today.
so really what we're thinking was a change in job an interview trigger, and it seems to be. I have been to a fair amount of green card interviews lately, and one of the things that seems to set off a green card interview is one of those is a late filed supplement J, and it seems kind of logical. You know, you're telling them at the last minute you're changing the entire grounds for the green card filing. So that's something out there. So job stability is important because if you need to change jobs, get a new I-140 new perm, that could be more than a year, and meaning you might miss your chance to file for your green card immediately, which could cause all sorts of problems like inability to extend your H-1B status if your priority date does become current. And at the same time, if you throw a couple of supplement J's into the works, that gives USCIS more to think about, and it could slow down your case. I mean, live your life, make your decisions, but know that these are issues that as your date gets closer, these are things that could change the calculus of your case.
So your advice, starting with 2022, is with the rollover coming through, with a lot of heat on USCIS to move adjustments quicker, with the recapture potentially coming through, that staying put, if you can, because I know a lot of times you may not be able to, staying put with your employer and avoid the supplement J if your priority date is close, to avoid the interview, try to avoid that interview and move your green card approval quicker. So that's advice number one we have.
Yeah, that's
that's a good summary. That's a good summary. Excellent. Now, be ready for request for evidence. So we've talked about what are we expecting in 2022 is a lot of RFEs on adjustment of status. By the way, I've looked at denial rates in the statistics coming from USCIS, and quite frankly, it's a healthy percentage. I don't have the exact number, but it is a decent number of denials coming out of USCIS on adjustment of status. A lot of people don't talk about that. So get ready for your request for evidence. And how do you get ready for request for evidence preparation, Brian, in advance of the RFE?
Well, so I will mention, what kind of issues we see, and obviously we'll talk about how to prepare for them. So the common issues we see are queries about, have you been maintaining your employment authorization? Have you been maintaining your status? Is your I-45 offer of employment still there, be it from an I-140 or supplement J? Sometimes birth certificates. And one thing that's got to be coming up, Sam, is medical exams. Medical exams last 2 years, and it's been over a year since we last filed since so many people filed I-45 in October 2020. Those are going to be getting stale. You could, as they will continue approving cases into this coming year, you could see your medical exams go stale, and you could see new RFEs on that issue. So how do you address all this, Sam? You look at your case. There's any number of attorneys out there who might be happy to, sort of help you reevaluate your case and figure out, what's missing. If there's anything you can do to stem off that RFE, like avoid that too.
We do have a robust adjustment status preparation program in our office, and I'm sure other attorneys have something similar to that. But I don't know about you, Brian, but there has not been a one that I prepared that I did not find something that you can improve on. There's obviously common issues because these cases were prepared in a massive rush, not on part of the law firm, but also on part of the beneficiary and the applicant. And there's a lot of issues with things that are not clarified in the application that needs to be clarified, and to just get it back and resolve that. I find a lot of things about, a lot of the questions about criminal background. If you ever had a speeding ticket, you just have to say yes to whatever question, 25, 26, I forget the number.
No, you usually know the number, and I'm always impressed by it. So you're right, Sam. There's so many issues in cases, and can you avoid RFEs in their entirety? No. You dodge left, they're going to shoot right, and that's going to and it's really hard to avoid them. It's just be prepared for it and be ready to know what the common issues are and be ready to address them. It's the sort of thing you can do yourself too.
Would you send a medical now if your priority date is getting closer to avoid the RFE?
Well, if you haven't set your medical before, I see no reason why not. And they last 2 years, so why wouldn't you? Occasionally, we see a case where USCIS says says they didn't get the medicals, and that's always the risk you take. But you're still trying to avoid the RFE. Sure.
So stay put. Look at your application. Look at your birth certificates, your affidavits of support if you submitted them. Example of cases I've done recently where I found areas for improvements is, for example, I reviewed one case recently, and in reviewing their employment, there was a bench period. 2 or 3 years before that, they were benched between two jobs. They did not receive a paycheck for 6 weeks. Then that's an INA 245K waiver. It's not a problem. It's not going to hurt your green card. But that person was going to the interview, and we prepared a very nice letter. Number one, because there are questions asking about, have you ever stepped out of your status? Have you ever violated terms and conditions of your status? And you probably answered no to all of them under oath. And it has no impact on your green card issuance, but it has an impact on whether you were truthful on the adjustment, and also whether you're prepared to address it in a way that you can get positive results. And we prepared the letters for them, and then they went to the interview, and they were able to let them know I was benched 3 years ago for 1 month and did not receive a paycheck. And by the way, here's a letter from my attorney explaining it and explaining why this adjustment should be approved, notwithstanding that incident.
Yeah, so one thing I got to say, Sam, is you mentioned, preparing people for interviews. What's your take? If you've been selected for an interview by USCIS, do you think somebody needs to talk to an attorney about that?
Yeah, I think so. I think you do. I think this is probably second or third most important legal process that you're doing in your lifetime. Yeah. The first probably milestone in your lifetime that I think is incredibly important is your degree or education. The second one is probably your marriage. Some people think it's their divorce, but I think it's their marriage. And then it's your green card. Then probably later is your citizenship. So, those are critical legal steps that you need counsel, and I think it's not incredibly expensive to make sure that you're covered.
Yeah, right now, in case anybody's not aware, employment-based immigration, most people don't get an interview, and thereby, if you do, there's something that USCIS thinks it's worthy and interesting to talk to you about and bring you in. So that's.
One more thing about adjustment that you think it's a big deal, Brian. Do you recall?
Well, I have one on my list, and it's more of a fun and happy one.
Yes.
Marriage.
Yes.
Probably about once a month, somebody asks me, "Hey, I'm planning to get married," and Sam, it's a simple rule for who gets to come with you when you immigrate to the United States. It's anybody who is your family member before you get a green card. So if there's any young gentlemen out there who are planning to get a green card and are thinking about getting married, find a way to get married first. That person gets to come with you. Now, granted, there's some challenges. There's the way the immigration climate is right now. You still may be able to file an immediate relative petition for your spouse right now, but it's something to think about.
We don't want to dive too much into the family immigration realm of things, but you can't avoid talking about it. Marriage, because now we're in a travel difficult situation. Marriage has to be recognized in the country in which that marriage was consummated. So so it has to be recorded prior to the green card approval for the wife or the husband to benefit from that. And U.S. law does not recognize proxy marriages. Proxy marriages is a marriage where you get married by phone. So there are certain countries would say, I can appoint an agent, like my father, my grandfather, who can go to the family, and he, on my behalf, can enter into the marriage, and therefore I became married. That is not recognized in the U.S. So you got to do it. You got to do it the right way for that marriage to be recognized here in the U.S. So that's it on the green card front. We want to talk a little bit about H-1B changes that we're anticipating. So we've talked last time about there may be litigation on one side of the equation. There is new regulation on the other side of the equation. One is challenging the similar memo and the travel requirements, and we think that's going to be resolved in favor of the employer. On the other hand, USCIS seems to be poised to put it back in again as a requirement if they pass the regulations. But we do not really know where that's going. But there are some advice that we can give you on the H-1B front. Brian, what's the first advice you want to give everybody on the H-1B regulations and litigation that we're anticipating in 2022?
My anticipation is that USCIS will likely be requiring the sort of documents that you had to provide in the past for H-1Bs again, your classic contracts, statements of work, and letters. I think that they are kind of peeved with us, their ability to ask for those things, demand those things, and that's something per the way we read the proposed regulation statement is something. And, my advice when times were really bad, a couple years ago when H-1Bs were hard to get approved, it was vet your client. Make sure that they are the sort of clients that are willing to give you these documents. Because if we see a regulatory environment change, regulations usually don't make things easier on people. New regulations are unlikely to make your life easier, I guess is my executive summary. So
on the other hand, regulations provide clarity. So one of the challenges we always had when processing H-1Bs on memos, and even memos that are vaguely written or not clear, where you read it and you go, I don't see what you're asking me in here, because they speak in this double talk about employer-employee relationship. When they talk about employer-employee relationship, it means they need the letter. It's like when a layperson look at it and say, well, you're asking me to write a letter for you. Give me the source to give my vendor that you need a letter. And we just give him this silly memo talking in language that is not English. And people say, where does it say you need to write a letter? As a matter of fact, it says the letter is not required, but the letter is required. So regulations have the ability to kind of provide clarity, and with clarity comes predictability, even if it's difficult. So I think while it may be difficult sometime, you can just take these regulations and give it to the vendor or to the end client and say, here's the regulations.
Point to it on the page. Say that, that's a good point, because I remember, again, we're in a good, happy climate right now for H-1Bs, but with change forthcoming, one of the challenges was saying, well, my vendor and client says, there's nothing that says I have to provide this, and perhaps a little bit of guidance there will make that transition a little bit smoother.
So our advice to our people watching, or this videotape or this YouTube, is to pay attention to the H-1B regulations in 2022, expect changes, and until changes happen, make sure that you're complying, because we're going to talk about something else also that kind of dovetails with that. Make sure you're following the H-1B amendment rules as they exist at the time that you need to comply. So right now, today, you have a requirement to have an H-1B amendment filed with USCIS when you change your location to a new MSA, or have a material change in your working conditions of your H-1B by your H-1B employer. You must have an LCA that reflects the work location. You must be paid the fee or the salary reflected in the LCA, and you must continue to make sure that you're complying. Until things change, stick to that, because the next thing we're going to talk about in H-1B is what, Brian? That is going to be really very prevalent in 2022.
Oh, I think you got to be talking about site visits, Sam. Site visits?
Site visitation. Yes. So what are we expecting?
So, Democratic administrations really love, compliance is one thing we've discussed in the past. So we can expect to see an increase of that. And they're also changing their policy and rules on site visits, changing the way the program works. So we are probably expecting a program with more teeth. So more site visits forthcoming, more interesting visits forthcoming. And, I guess we've talked about this in the past during our presentation, Sam. It's learning about how to deal with USCIS officers when they come to see you, because you're not going to have a lawyer present when some USCIS officer walks into your work site. How do you deal with them? You deal with them professionally. You deal with them courteously. And ultimately, Sam, you have to make sure so your number one best defense, Sam, is like you were saying, is make sure you're complying. Why? Because who faces the penalty when you're not in compliance with your H-1B status? It is you. Some people have an attitude of my employer is going to take care of it, and most employers are really good, and they do. But if there's a problem found, you're the person who's going to lose your H-1B status in the United States. That's really, really the thing that sticks in our head. The employer loses their employee. You lose your entire life inside the United States. Is the real challenge there. So I guess it goes without saying, Sam. Know the rules as they are right now, and know the rules that they are to come, because it's your life on the line.
I agree. Moving on to premium processing is the next topic that is we think is going to be critical for 2022.
Yeah.
Premium processing, obviously, as we were talking, it's going to be something that we think is going to happen soon for a lot of reasons. The least of which is the fact that USCIS is desperate for money. Right? USCIS need money badly. They find that all are willing to put money for them to do their job right, extra money, is something that is very attractive for them. And they would love to charge you $2,500 to issue that EAD that they're supposed to issue it on time, and they don't issue it on time, and they delay it. So premium processing for a lot of other services is going to be happening in 2022. And therefore, what's your advice on this issue, Brian, in terms of premium processing?
Sam, this is not advice I like giving, but it's save your money, because premium processing will be needed. Do you expect the backlogs to get any better, Sam? Do you expect them to move? Cases where they get premium processing money, they have an obligation. Otherwise, they have to give back the money. They have to meet the deadline. If you're not in premium processing, it won't be a good spot to be in when the new premium processing is available, because I expect deadlines, backlogs to get bigger and bigger. There's certain things that sort of point to the backlogs going away, like the E2 and L2 EAD visa rules that changed a while back, but. We all know how bad the processing times are right now, and if you're telling me that everybody else the people get to jump in front of the line of the premium processing, I don't expect them to move cases faster.
Yeah, and that's what we have for things to change. So we're going to turn the table and talk about waivers and things of that nature. Let's jump on the waiver and see what's in there. So there's new policy by the State Department that talks about a waiver, and there's really two different things going on that's confusing people. One is a rule about waiving in-person interview, and then the second one about extending an existing Dropbox rule, which is basically, in essence, is a waiver of interview, but it's kind of, there are two things going on. So with regarding to the waiver that we are dealing with, deals with anyone who had received a prior H-1B approval in their country of residence or country of citizenship, and they had a prior approval, and the visa benefit that they're seeking is one that was issued by USCIS. And if you have that situation, the consulate could exercise discretion to waive the visa interview for you and issue that benefit, such as an H-1B visa, for example. And there's no 8 months on that, and does not have to be the same visa type, right, Brian?
So I have a great example of this. So basically, the requirements are you have to have an approved visa petition, and there's so many categories that are available, like H1, H3, H4, L, O, P, or Q. So if you have a visa petition approved in one of these categories, you can essentially get visa stamping, provided you're going back to your home country and you haven't been refused a visa and you have a previously issued visa. So the classic example is this: you come to the United States on an F1 visa, right? And congratulations, you recently changed to H1B status, but now you want to go travel to your home country, and you say, oh shoot, if I want to come back on H1B status, I have to go for H1B stamping. Maybe not. Again, per this policy, the Department of State through the consulate has the discretion to waive your visa interview. They can basically say, this guy or gal, we've already seen them for an interview before. They've never been denied a visa. They have an approval for an H1B petition, for example. They're good to go. It's a pretty nice scenario. It basically really eliminates the problem of the consulate, of the massive challenges of getting a visa. It's not a guarantee, though. People have asked me since this policy came out, that's a guarantee, right? Oh, it certainly is not. The consulate can call you in for a visa interview for whatever reason they want. Click a wrong box on your DS-160. Oops, you're in the interview zone. I mean, granted, maybe interviews won't be so bad right now because they'll actually have time to do them, but it's something you have to think about carefully. I guess you're taking a risk. There's always a risk in travel abroad from the United States.
And for visa waiver countries, obviously, you don't even have to have had a visa before.
Yeah, which is awesome.
Yeah, which is great, but obviously not for everybody. Now, so that's the visa waiver that we have. And there was somebody that asked me, does it apply for an L1A blanket? And I initially thought it did. And we've gotten some indication that the visa waiver was supposed to include also L1 blanket, but there was a little bit of a retraction on kind of a strict interpretation. They were going to interpret it in a very broad way and allow also L1 blanket, but that looks like it's not going to happen. So L1 blanket, because it is not an individually approved visa, it does not apply to them, which it makes no sense whatsoever. But it is what it is.
I can't help but point out the obvious loophole for that. If you have an employer and an immigration attorney who's willing to go to bat for you, file your own individual petition inside the United States, get that petition approval, and then suddenly you might be eligible for a waiver.
Yes, I mean, if you have an L1A blanket, just go in and get an L1A individual. You should be able to get that.
Yeah.
No problem, especially in premium processing, and get that out of the way, and then get stamping if you've had a prior stamping before, or if you are from a country that supports the visa waiver program, you don't even need to have had one before.
So we got to talk about the other side of the visa interview craziness going on right now, Sam. That would be the Dropbox extension, which is up to 48 months right now.
Yeah.
So lots of people they ask questions about it all the time, familiar with the Dropbox. It's basically you're renewing your visa, same category in your home country. You've never had a visa refusal, and you have to have last had a visa your visa expired in the last 48 months. And that sounds great. It's really been helping a lot of people. But Sam, you were making the excellent point earlier. It seems that this new policy kind of mostly swallows up the visa waiver policy, the Dropbox policy, right?
Well, yeah, we were talking about that, but our Joe Mohart, one of the attorneys that work with us and supports us in some of these, he works he's the brain sometime behind some of the stuff that happens in the office. And he was pointing out that the discretion level is a little bit different, where with the Dropbox rule, it seems to be uniformly accepted if you meet the 1 through 6, 1 through 7 requirement. You've had visa that was valid during the last 48 months. Now it's 48 months, was 1 year. It's the same type of visa. You're about 14 years of age, issued in your same country of citizenship or residence, et cetera. Then it looks like it's almost not exactly 100% automatic, but the exception is to have an interview.
Yeah. Executive summary: you have a better chance of success if you're, in the Dropbox renewal category versus the broader waiver, which we just talked about.
It sounds like it, because it's been established for a long time.
Yeah,
right?
That's true.
And there's a system in place, which is a good thing. So that's really the distinction. That distinction is more practical, but legally speaking, it seems to me any waiver consumes any Dropbox rule. In terms, I mean, if you qualify for a waiver under the Dropbox, you qualify for the regular waiver
Yeah.
as well. But
Yeah.
all what you need is one waiver. Yeah,
Yeah.
absolutely.
So first of all, we are going to do our usual Q&A session. So everybody have your Q&A queued up and ready to go. But we'll talk about the process briefly. It's essentially if you already have a case in process with the consulate, they should contact you about whether or not you're eligible. But moving forward, the DS-160 or the visa process should have questions that will ask you basically ask you questions about your eligibility and direct you accordingly. So it should be pretty much transparent to you guys. You shouldn't be, looking for a secret code in order to make you see if you're eligible for this. It's in the interest of the consulates to basically waive your interviews anyway. They'll be happy to do it. So they're trying to figure this out for you.
Yes, good point, Brian. And we're going to go now to the Q&A session. And without further delay, take a 1 minute break. All right. Q&A, Brian. What's our first question? So I have somebody who was really saying to you and to me, Happy New Year, Sam and Brian. Thank you so much. Happy New Year to you as well. And we appreciate listening to us, supporting us, and hopefully you're benefiting from this program. Brian, you want to take the Q&As or you want me to run with them?
I can run them. Tables are turned. Brian is remote. I have gotten caught up at home today. I'm in my luxurious basement where so many people have a tendency to work out of during the all COVID pandemic. So you guys get to see it live and not in person, but
If we go into that view, do you think we can put the whole question underneath? Yeah, that looks a lot better, right?
Oh, that's beautiful. Wow.
Yeah, I like that. Wonderful.
Now see, Sam, I have all the silly stuff I keep in my basement, put in this black region over here, so nobody can see it for the record. But let's get to the questions.
Go ahead, Brian.
So, trying to get clarity around the interview waiver for visa stamping. Does one still need to schedule the appointment through the portal, or could we assemble all docs and walk into a Dropbox location? So, we just sort of answered this question about 5 minutes ago. You go through the visa application process, and they should basically be able to let you know. Essentially, if you're eligible, you'll be asked to come into to go to the Dropbox location and drop off your documents. You'll be asked for an appointment. You'll be given an appointment. Yeah.
Could you dedicate a session for visa stamping in the next session? I think it's a fantastic idea. Absolutely, yes. We are going to, as a matter of fact, do a visa stamping session next time.
I think okay. All right. That sounds good to me.
Yep. Take that one, Brian.
Sure. So the A number in the I-45 receipt is different than the one filled up on form I-45 for the pendant. Is that an issue? I've not received a receipt for I-45J. When will that be sent? So, I can think of a likely explanation for this scenario. So on your dependent's I-45 filing, I would bet that the A number put in there came from an H4 EAD. An H4 EAD has an A number, and that is not a permanent A number. When you officially register for adjustment of status, when you officially file for adjustment of status, they give you a permanent A number. And I would suspect that that's what happened here. When you get that I-45 receipt, they give you that final green card A number. And that's probably what's happening there. The other question was about the supplement J receipt. I had filed my I-45 and haven't gotten a supplement J receipt. I can tell you this. Think of how one of these I-45 applications gets filed. That supplement J is usually buried pretty deep down in there because that's kind of where it needs to be after the I-45. And we usually don't see those supplement J receipts until pretty far after actual receipt of the filing. And usually right when pretty deep into the process of the case when we're thinking they're more getting ready to actually adjudicate it. So that you don't see an I-45 supplement J receipt immediately upon filing a case is not crazy to me. It could be pretty far down the line that you actually see it.
Good point, Brian. And we have a happy new year from Suku. Thank you so much. Well, happy new year to you as well,
Yeah,
and to
happy
your
New Year
family.
to you. Yeah.
How many months and weeks do I have to expect my I-45 approval after biometrics with the National Center?
Nebraska
Well,
Service Center. So,
Yeah. So, I mean, unfortunately, there's really not an exact time, because when you do the biometric, there's going to be a process by which they're going to do a background check on you. But we're seeing it usually. I mean, not every case, because we're seeing some cases getting stuck for a while, but we're seeing it 4 to 8 weeks, I think, maybe closer to 8 weeks.
Well, I'm thinking, well, this is saying, do you have to wait for I-45 approval after biometrics? Actual
Yeah.
I-45 approval
Yeah.
after biometrics, I mean,
Yeah.
anywhere from weeks to years.
Well, yours is harsh if there's a retrogression. But
Yeah.
let's assume everything is okay and things are moving fast. I mean, basically, they have to go through a background check. And the background check is multi-agency background check. So if your name came up, I mean, in prior years, we've had big issue with name crisscross, meaning that your name is similar to another name who is not really a nice guy. And that causes a lot of delays. But let's assume no issues whatsoever. Let's assume there's no retrogression in the visa. What we're seeing is about maybe a couple months to get your approval after the biometric, if everything goes okay in the perfect world. Let's put it that way.
I think that's in the perfect world, because I think we are kind of in an imperfect. I mean, there's also these questions of this is for Abby Addy that is your priority date current? If your priority date's not current, they're not going to be approving your I-45. So, and the way they've been moving the dates around over the last year. So, I guess, Sam, typically when somebody asks me if everything's normal in normal times, how long is my I-45 going to take? I say 10 to 12 months to approval. So do the math there. But we are in strange times, and the way the dates are wobbling back and forth, people are getting some uncertainty.
We've had a recent case in which there was an interview, there was an expedite, there was an aging out issue. Everyone positive, and all of a sudden it got stuck. And it's just like, and we're just, the guy's going nuts because, it's costing him a lot of money because of his son, also paying extra money because his son is not a permanent resident. So, and in any case, got stuck. But perfect case scenario, yes, couple months. And if you get in a couple months, you're very lucky.
Well, yeah, there's the rest of the follow-up there from Abby. And so I guess my take on it is, I don't think anybody can really give you a definitive answer to that question. It's, you just have to have the dumb, silly luck be the next case that a USCIS officer picks up off the shelf, provided your priority date's current. If your priority date is not current, you just have to wait that out,
Fine, take that one.
Sure. From our friend Sweet Seller. So I want to check how bad I am with my prediction for Visa Bulletin for EB2, for February Visa Bulletin EB2 final action date. My predictions: 1, if dates of filing gets accepted, final action date 9/8/12. If final action date only gets accepted, 10/1/2012. Thoughts?
Well, I'll take your dates. I'm looking at it here. We have obviously a new system.
New person, somebody replacing Charles Affenheim. Yeah.
So right now we're really in uncharted territory in terms of predicting what these dates are going to be. But I like your dates. Brian, what do you think?
I think, pointing out that Charles has departed and somebody else new is at the reins. He said, the last thing he did before he left was basically help them out with the January Visa Bulletin, as I recall. But we are in uncharted territory. And I think if I'm a guy doing in a new job that's very kind of public facing, I can't help but think you're going to be conservative in your actions. You move the dates forward conservatively to avoid cheesing people off later with retrogression.
Well, it all depends on. I mean, again, they could be more aggressive as well. I mean,
Yeah, no,
I don't know.
I wouldn't be frowning about that, but I guess can't help but think of it that how I would approach that job.
I, I would agree with you on that prediction because honestly, you just gotta start slow. I mean, if you're in a new job and it's a serious job,
Yeah.
you can get a lot of people mad at you if you make the wrong move.
I mean, yes, Charles Oppenheim, who did really well with damaged data from USCIS. If you looked at the comment section on his monthly chats.
So is the Dropbox rule applicable to a change from L1 to H1? The answer is no, it is not, but the waiver will be. So you could apply for a waiver of interview under the new policy if you've had a prior visa approval. Brian, you want to talk? Go ahead.
Yes, but unless it's wait, no, that's never mind, Sam. I was thinking about the L1 blanket rule, but that would be about changing to L1. And this is not a change to L1. This is a change away from L1. I rescind my hand raising. Yeah.
That's okay. That's okay. But So the Dropbox rule is not applicable. It has to have you must have had the same visa approved and has not expired during the last 48 months.
Yeah.
For the Dropbox rule to apply, you're applying for a change of status, and that is not.
The Dropbox rule wouldn't apply, but the new visa waiver rule allowing you to, as long as you've had an L1 visa in the past or some visa in the past, which you clearly have, they may be willing to waive your interview because you've had a past visa stamping.
So Abby is in the envious but painful position that his priority date is current, which means any minute right now. How do you even sleep at night? I mean, I would be thinking about it every night, man. I mean, this is very stressful. But yes, fingerprints are done, looks like. Priority date is current.
Anytime?
Any minute, any minute, yes.
They have posted processing times. If anybody's not aware, you can go to the USCIS website and see what the processing times are. Depends upon where your case is. If your case is, your case might be at your local field office, based near whatever city you are, or it might be at one of the National Service Centers. But they have posted processing times, and they are stated to be pretty long. But I know plenty of people who've gotten their October 2020 filed green cards in about 10 or 12 months. So it is possible, but you're just kind of at the mercy of when somebody picks up your case.
Yes. So somebody's telling us our sound echoes and then telling us Happy New Year. Thank you so much for your feedback. I don't know if I got it better. I tried to kind of turn the volume, maybe Brian's voice.
I think it's me coming back through you, yeah.
Yeah, so I turned my end of it. Hopefully that helped. If not, we'll look at it further. Give me feedback if that echo is gone now or has gotten better. We appreciate your feedback. I think we're probably going to do some equipment upgrade here soon to kind of get rid of some of that. But Brian, take that next one.
So another question here from Sweet Seller. So it's when filing when dates are current and dates of filing versus final action date. So he's asking if adjustment of status with dates of filing is a bad idea. So is there a risk the applicant could be stuck with an EAD only, even if the dates become current? And I presume he means, final action date current. So it's worth explaining what dates for filing versus final action dates are. So on the visa bulletin, there are two lists of numbers. There's dates for filing and there's final action dates. And dates for filing are essentially a look forward. The dates for filing are what the Department of State thinks will become final action current in 8 to 10 months, I think is what Charles Oppenheim said. So basically, it's dates they think will become current soon. And the logic of having those dates for filing is, hey, send us your case now, such that we have time to work on the case, such that by the time your final action date is current, we'll hopefully be able to prove it right then without having to increase the amount of time you're waiting, essentially. So there's very few scenarios under which I could say filing under dates of filing, if you're eligible, would be a bad idea. Because, again, your final action date is expected to become current. So I don't see how one could be stuck with an EAD only. Eventually, your date will become current, and eventually, when your date is current, they'll have to approve or make a decision on your green card case. So,
but to answer the question directly, filing under date for filing is not a bad idea.
Well, I can think of one. I have one scenario where you got to think about it, Sam. It's the Child Status Protection Act. Perhaps if you're going for a second filing, A second adjustment of status filing, you would want to make sure your kids would still be, your kids, if your kids are already, if you have older kids who are locked in under your first filing, you would want to make sure that they are locked in under your second filing. And if you're not final action date current, that's a problem. You're not going to be, you may not be locked in under the Child Status Protection Act.
So the scenario you're talking about is you have an adjustment of status that's been filed in already,
Yeah.
and then you file a second adjustment of status.
Yeah.
Under date for filing. I don't think it's a bad idea, because if it's under date for filing, okay, for that case, obviously there is an aging out question.
Mm-hmm.
Obviously, there are strategies, because there are
Sure.
potential advantages of filing under date for filing when you withhold the medical to make sure that you're protected, because sometimes that category can move quicker and be better for you. So I wouldn't see it, I wouldn't call it a bad idea. I think that would be
I think I shall revise my language and say it's something you should think about.
If you have a second filing and you're filing in the date for filing, you probably need to consult with counsel to make sure, from a strategy standpoint, you're positioned correctly to maximize your case going forward. But I wouldn't go as far as calling it a bad idea. 99.9%, it would not be a bad idea, because all what you have to do is, for example, withhold the medical so you can control the timing on this case.
Yeah.
Well, so they can move quicker.
The nightmare scenario is that basically some family, if the wrong adjustment of case gets approved when their family members aren't locked in under the Child Status Protection Act, that they would miss out on a green card, and that would, of course, be terrible.
Right, and so the likelihood of that scenario, so our people know, probably 1 in 1,000.
Yes.
And if you do it with counsel who has experience, they will help you for that not to happen. So I wouldn't call it a bad idea. You and I I'm disagreeing calling it a bad idea, because it really cannot, most of the time it really is.
No, I agree with you, Sam. It's just something I think about. I think about this when we file second adjustment of status cases for people.
Is there a scenario under the sun in which filing under date for filing is a bad idea? There's probably one. If you go in stratosphere somewhere, there's a spot over there, but under normal circumstances, it really is not a bad idea. On the same page?
Yeah, I agree.
Yeah. All right, so there's a gentleman here who filed for EB1 by himself. So I'm assuming if you filed EB1, so extraordinary ability, EB11, my employer said they will file it for you. Earlier, they were going to do it in EB2. Well, a second petition by my employer in EB1 has a negative impact, cause an issue. Well, I'm going to give the short answer, and I'll have Brian give the elaborate one. The answer is no. No, there is not an issue whatsoever in your employer filing an EB1, perhaps under multinational manager or executive, like an EB1, 2, or under outstanding researcher or scientist, if you are in that category, and you file under extraordinary ability. Brian, you want to elaborate?
No, I think that's pretty concise. I mean, you are allowed to. I mean, we deal with people with multiple I-140 petitions in, say, the EB2 and EB3 category, and it's not a problem for the government. They are happy to give you a green card through whichever way you are able to get there first.
So Ron has a successor in interest question. After acquisition, my successor of interest amendment of I-140 is denied. Can I still port my priority date to the newer employer? So I don't think a successor of interest denial affect the priority date of the underlying I-140.
No, it should not. As long as, I mean, basically, you get to keep your priority date unless it comes from fraud or misrepresentation. I don't have any sort of hint of that in this scenario. Yeah, you should be able to move that to another company.
So who is the gentleman? Ram has a follow-up, but I'm trying to remember his question. Do you recall his question? So Ram says initial initial one was approved in 2014, and I'm trying to remember what was he asked about initially, and it just too far back now. Sorry, Ram, I don't remember your initial question. We're moving on to the next one.
Okay. All right. So
Here, I think I found Ram. Let's go back and revisit Ram. Okay, so successor in interest.
Yeah.
Same person. So he was the right after. Sorry, I was looking in the wrong spot. So yes, so your pilot is 2014. There's no impact. You just need to find an employer that can file a new labor certification for you, and then file an I-140. And when that's approved, no problem. You get your priority date 2014, and you move forward.
Yeah.
Right? Fine.
Yeah.
All right, sounds good. So moving on to the next one here. Take that one, Brian?
Yeah, sir. So this is from Sneha Mehta, and so it says, "I'm a green card holder and want to sponsor my nephew for a green card who is 16 years old. Is it possible? If so, under what category can I sponsor him? Thanks." So my first answer is, can you sponsor him? No. However, there may be somebody else who can sponsor him. So basically, long story short, in family-based immigration, you're not able to sponsor a nephew. I can't help but think, there might be a way to get your nephew to the United States. Who you can sponsor, I realize, is limited as a green card holders. But Sneha, here's what I think about. I think about you becoming a U.S. citizen, and I think about you perhaps petitioning on behalf of your nephew's parents, a brother and sister. That is something you might be able to do. And then they might be able to bring him with them. So is it possible for you to, in a roundabout way, petition on behalf of your nephew? Yes, but it's potentially a very long and complex process.
Excellent question. So there's a question about marijuana and a position of 30 grams of marijuana, and I'm going to that question right now. A single position of marijuana, 30 grams 2 years ago, does it have an impact on the green card? Brian, I think, it looks like he has a green card. He's asking about naturalization.
Yes, and
so that's a good question. Maybe I'll take a stab at it, Brian. So first of all, you have to look at, first of all, what's the area in the law we're talking about? It's good moral character, right? The question has to be is whether or not you're deportable. That's number one, because you got to answer that question, and you might be. I'm not sure the minimum grams that will trigger deportability. I used to do deportation many ages ago.
There's a marijuana exception, Sam, for cases less than 30 grams.
Right, that's the question. Is it 30 grams the magic weight?
I believe so. And does that say more than 30 grams or less than
30 grams?
Less than 30 grams?
So I think he's okay. I don't remember whether it's 15 grams or 30 grams. I think it got changed in the last 15, 20 years. So the question of deportability is not being asked, but that needs to be looked at. And hopefully it's 30 grams. I wanted to Google it quickly. I couldn't, obviously, do it. But
I have Googled it recently. 30 grams.
Okay. So good. So let's assume there's no deportability problem, right? So we move on to naturalization. The question is moral character. There's two things about moral character you should be aware of. What is moral character? Moral character is your character in the community as compared to an average person. Okay, so you don't have to be a superhero to get naturalized. You just have to be an average person. So that's number one. Number two, there is a 5-year look back at the time you naturalize into whether or not you maintain good moral character. Now, if this 2-year and you said, is it 2 years ago?
Yeah.
Green card for 10 years. So if it's happened, if you were pled guilty 2 years ago, you are within the 5 years. And if you are within the 5 years, you're not going to naturalize 99%. What you want to do is you want to wait more than 5 years, and then any probationary period has to also terminate 100%, and then you count 5 years, then you apply for your naturalization.
Yeah.
Now, is that enough? Yes, probably. Now, what do I do more to be prepared?
Oh, I know what you do, Sam.
Hmm?
Build up that. You build up that good moral character, right?
Well, I think, yeah, you want to build up more character. Exactly what Brian said. What you want to do is invest into good activities in the 5 years, such as community activities, volunteer activities, nonprofit activities, church,
Church, temple, mosque.
synagogue,
Yeah.
yeah, temple, whatever it is, and create this really nice resume of activities that reflects in a positive way on you, and you'll be fine. You will be naturalized. So consult with an attorney before you file an application. This is not an application you file on your own, 100%. Well, you can file on your own, certainly. It's just not. I wouldn't recommend that.
It's the sort of thing where, I mean, we would go, wow, and if this came up in practicing one of our cases, we'll talk about the things you just said with the client, obviously.
Yeah. So yeah, it's not possible, but premature right now if the conviction is 2 years ago.
Yeah. Can I naturalize? Yes, probably. Right at this moment, perhaps it's not your wisest use of time.
Yeah.
Yeah.
So Sweet Seller had a question. He said, "I'm talking first filing with no age-out children."
Well, there you go.
So I think he's talking about whether or not filing under date for filing where is a bad idea. Was that the question?
Correct. Yes.
Yeah. So no children, no age-out questions. I think you've just wiped out any opportunity for any bad idea.
I agree. You want that green card.
Thank you, Sweet Seller, for bringing Brian and I to consensus on this issue.
Well,
so now Brian and I are full agreement.
Yes, I like that. Life is good that way.
Yes. So we have an H4 EAD questions expiring January 25, and H4 EAD not approved. Okay. I'm assuming she, meaning the spouse, has a green card EAD not used due to teenage son. Not used green card EAD due to teenage son. EB3 June 2014. My question is, can wife's son use green card EAD advanced parole and then can switch to H4? The answer is yes. The first part of the question is yes, you can use the green card EAD. Now, can you switch back to H4? Yes, but you have to go through the step of obviously leave the country and re-enter at a time that's convenient in the future. I wouldn't quit my job. I would use it if your employment, if your green card and employment is stable, I would go into green card EAD in the scenario. Brian, you want to throw in a little bit more details on that?
Yeah, I'd say, well, first of all, I just got to say you're right. You know, Sam, people love to ask us, we're attorneys, ask us about gloom and doom scenarios, but most employment-based green cards get approved quickly, reasonably well, no problem. So there's that. I'd say, you know, I'm confused about the teenage son scenario. I think there might be a mistaken perception that your spouse using the green card EAD will put the child out of status. No, that child, if that child is maintaining their non-immigrant status, such as, you know, H4, they can keep on that status independent of their parent who may leave it behind. Really what's you know, in order for that child to maintain their H4 status is contingent upon, you know, the primary H1B person maintaining their H status. So yeah.
Excellent. PP is giving you a follow-up.
Yeah.
I'm requesting an EB1 filing from my company, so if we use green card EAD advanced parole for EB3, can I still file EB1 if primary applicant cannot? Can dependent use EB3 EAD advanced parole and file for EB1? Well, you got to be careful because once the spouse and the son get into this EAD green card, they cannot file an adjustment under EB1 right away. Now you can, if you maintain your status, no problem, and you could proceed in that direction. Obviously it's current, and you could also add your family later, but I would not go into green card EAD. Thanks for adding that clarification. Until after the adjustments are filed, all the family filed their adjustment. Now, the moment you file the adjustment of status, a question I think he has, let's say I filed my adjustment of status today, it's received by USCIS tomorrow under EB1, I believe he's asking that, can now the family jump on the EAD EB3 based on the EB3 adjustment? Brian.
So that's a question of some controversy, is it not, Mr. Sam?
I don't think you would violate the terms and conditions of your adjustment of status if you have an approved adjustment of status EAD under a different classification.
I tend to yeah.
Brian?
I tend to agree with that. I mean, I guess our matter of controversy is using that AP from another case is what we were talking about, using that AP where we hit that before.
It's valid and the offer of employment is valid, still okay. Don't rely on this advice, and because this is a life-depending kind of movement. So what you want to do is you want to consult with a competent attorney to drill deep into the intricacies of your case to give you a more of a precise answer, in my opinion. I don't see a problem on the face of it, but every case has a lot more details in it, and this is like a huge move for you. So in general, that's the answer, but the better answer is consult with an attorney on that one. Brian, you got something to say?
Yeah, because we love to add facts and make for more interesting conversation between us, but taking PP's narrow question, I read it as this. It's basically saying, if my wife and son are using their green card, their EB3 green card EAD advanced parole, can they file for adjustment based upon the EB1 I-140? And that's a problem because they can't do that because they have to be in status to file an employment-based adjustment. So, yeah.
Yes, that one is right on. Yeah. I agree with you. He can if he's maintaining his H-1B or L visa, whatever situation he's in.
Yeah.
Wonderful. Well, thank you guys, and thanks for Christopher York for the kind compliment. You guys have a fantastic 2022. We're going to have a lot of fun this year, and we're looking forward to hopefully have a very positive immigration experience for 2022 going forward. Take care, guys.